Labor law. The first concept in labor law is trade unionism in India. This question is asked for 10 marks. Trade unionism in India. The synopsis for this is you have to write about history, historical development of trade unionism in India. You have to write about the development of trade unionism in India, Indian Trade Union Amendment Act 1947, and then you have to write about Trade Union Bill 1950. So, what is the history of trade unionism in India? See, the history of trade unionism in India can be traced back to 1890 during the British rule, when the first association of mill workers called Bombay Mill Hands Association was formed. The first association of mill workers was Bombay Mill Hand Association. It was the first association of labor that was formed. So during British rule, there was a lot of agitation and frustration against the British dictatorship. So there were a lot of strikes that were going on, and most of the strikes of these laborers were successful even during the British rule. So and even in the not in just in India, the in the global side, the trade about the trade union, the awareness was going on. So all this, the strikes and all of this led to the development of trade unionism in India. So the Royal Commission of Labor in India has observed that for a trade union to be fully effective, it demands two things. One is a democratic spirit, and other is education. For trade unionism to be fully effective, there should be two things among the laborers. They should have a democratic spirit, and they should be well educated about trade unionism. Second, development. So when how the trade unionism developed in India after independence, the democratic spirit among workers was increased. After independence, the democratic spirit among the laborers started to increase. So Mr. N.M. Joshi, the then General Secretary of All India Trade Union Congress, successively moved a resolution for measures by government for protection of trade union. He passed a resolution. So the Trade Union Act was enacted in 1926, and it was enforced in 1927. So in development, you have to write about the trade union enactment. It was enacted in 1926 and was enforced in 1927. There are two components of industry: capital and labor, that you have to mention. So in 1929, there was an amendment. The amendment said about a registrar for registration of the trade union. You have to write in development. The next point you have to write is Indian Trade Union Amendment Act. So what happened was the Trade Union Act was formed, it was enforced, but the employer refused to recognize the trade unions. The employers refused to recognize the trade unions of the labor. So a need arose for the recognition and for a proper provisions to make the employer recognize the trade union. So Indian Trade Union Amendment Act 1947 was formed for the recognition of trade union. So it says that after a registration is applied and the employer fails to recognize within 3 months the trade union, then they could apply to labor court and get the recognition from employer. So what happens when they get themselves registered and recognized the trade union? They get certain powers. The trade union gets certain powers. They get the power of negotiation with the employer. They get the power to strike and etc. We'll see it in further. The next is Trade Union Bill 1950. So in this you have to write that the by 1964 Act, Indian was deleted from name. Before it was called as Indian Trade Union Act 1947, but in this bill they removed the term Indian and they made only Trade Union Amendment Act. So first you have to write about history, that the British rule there was a lot of agitation and strikes were going on and that led to the momentum. And you have to write about development, about the trade union formation and all. And you have to write about the Indian Trade Union Amendment Act, where you have to write about recognition. And Trade Union Bill 1950, you have to write that Indian was removed in the name. Second question is the definition of trade union. It is covered under section 2H, the definition of trade union. So what is the definition of trade union? What is a trade union? Trade union is any combination which is a temporary or permanent any combination of persons which is temporary or permanent for the purpose of regulating relations between workman or workman and employer, or employer and employer. So it is a combination of persons. They have a purpose. They should be formed for a purpose, and the purpose is also given. The purpose is regulating the relations between workman and employer and employer. These are the purpose. Apart from this, if the combination is formed, then it is not a trade union. The object here is mandatory. It should be composed for the regulating relations between workman, or workman and employer. And the second purpose is to impose restrictions on trade. The second purpose is they can impose a restriction on the conduct of the trade and business of the employer. But there are certain exceptions to this B. For to what extent they can impose restrictions on the trade union? They cannot impose restriction on the agreement between partners. So say there are two partners of business, the trade union cannot go on strike to reject the agreement. There is exception. They cannot restrict the agreement between partners. They cannot restrict the agreement between employer and workman, and they cannot restrict the agreement of sale of goodwill. If the company wants to sell its goodwill, its name, then they cannot do any restrictions for it. These are the exception. So there is a case in it, Performing Rights Society versus London Theatres for Varieties. So what happened was, in this an association was formed, a combination of person was formed, but the object was different. The object was they wanted to protect the copyright of their substance. So it was not considered to be it was held that it was not a trade union, because the object was to protect the copyright and not mentioned in the section 2H. For a trade union, the purpose should be compulsory what it is specified in section 2H. It should be for the regulation of relations between workman, or workman and employer, or employer and employer. The next question is registration of trade union. This is one of the important questions. The question comes as explain the registration of trade union and its cancellation. So you have to write all these sections. The synopsis is this: Section 3, appointment of registrars. Section 4, mode of registration. Section 5, application of registration. Section 8, registration. Section 9, certification. And Section 10, cancellation of registration. So first, Section 3, appointment of registrars. So for a trade union to get registered, there should be a registrar. The registrar is the person who will register the trade union. So who is this registrar? So who appoints this registrar? The registrar is appointed by the appropriate government. So what is an appropriate government? If the trade union object is not specified to state itself, then the appropriate government will be center. But if the trade union object is specified to state, within the limits of state, then the appropriate government will be state. So appointment of registrar under section 3, they are appointed by appropriate governments, and the appropriate governments also appoint additional and deputy registrars under section 3 itself. First they appoint registrar, the appropriate government, then they appoint deputy and additional registrar. And when the appropriate government specifies the deputy and additional registrar the work of registrar, then they will be deemed to be considered as permanent registrars. For section 3, appointment of registrars. The next is mode of registration. How they can register, how the trade union can register, the mode of registration. Under mode of registration, there should be minimum 7 members in the trade union. If there are minimum 7 members in the trade union, then they can go and register. And the trade union should consist at least 10% of the members should be working in the same company of the trade union. At least 10% or 100, whichever is less, should be working in the same company. And while registration, if more than half of the person of the trade union leave, then the registration will be considered as invalid. If during registration, if more than half of the members of the trade union just leave, then the registration will be considered as invalid. So there should be 7 members. Then it will be considered, they can apply for registration. Application of registration. So on what manner they can apply for registration? For the application registration, there should be 7 or more members, or at least 7 members. They must have subscribed their names. So yeah, for application also there must be at least 7 members, and they should provide an application. and the application should be in the form A, be accompanied with copy of rules of trade union and statement of following particulars. So the application they are submitting, these 7 members, it should contain the rules of the trade union. They have to specify their rules on the in that of the trade union, and in that along with the rules, the application should contain the names, occupation, and addresses of the members making the application. See, it's not just laborers who can make register or create a trade union. Employers also can create a trade union. So, in case if it is not a workman, if it is an employer's trade union, then they have to specify their names, occupation, and addresses of the members of the 7 members who are making the application. Say if it is a workman who are applying for the trade union, then in that case they have to give the names, occupation, and addresses of the place of work of members. In case of workmen, the name of trade union and address of its head office should be specified in the application. And the title, names, ages, addresses, and occupation of the office bearers of the trade union should also be specified. So the trade union also has office bearers. They have chairpersons, etc. They should be specified in that application. That is the application of registration. How they apply? They have to include their names, office registration numbers, etc. So the next is registration. So under registration, the registrar will verify everything, the application, the mode, and if everything is satisfactory to him, then he will register the trade union. The particulars of the TU will be trade union will be verified by the registrar, and everything, if everything is in accordance, then he will register the trade union. There is a case under registration. IFCO Fulpur Karamchari Singh versus a registrar of trade union and others. IFCO Fulpur Karamchari Singh versus registrar of trade union and others. So in this, once registered, the certificate of registration holds good. So once registered, the certificate of registration holds good until it is cancelled. The registrar registering change of names of office bearers is not registration of TU. So what it in this case, what it was held that if the registration is done, then it is for permanent itself. No one can, until the trade union itself applies for the cancellation, it will be permanent registration. So next section is section 9, certification. After registration, it will be they will give us a certification of registration. Another certification that you have to write. The next is cancellation of registration. The next is cancellation of registration. So how the trade union will get cancelled? How the registration of the trade union will get cancelled? The power to cancel or withdraw is within the registrar. The registrar alone has the authority to cancel the registration. So when will the registrar cancel the registration? There are certain conditions. If that are done, then the registrar has the power to cancel the registration. On the application of trade union in prescribed manner, if the trade union itself applies for the cancellation, then the registrar can cancel it. If there is a fraud or mistake in the application, then the registrar can cancel it. If the trade union ceases to exist, then the registrar can cancel it. If the trade union will fully, after notice from the registrar, contravene any provisions or continue to rule inconsistent with the provision of the act, if they don't follow any rule law, then the registrar can cancel it. So there is a case, Tata Electric Company Officers Guild versus Registrar Trade Union. In this, it was held that a trade union did not submit returns, confusing the year of submit. So what happened was the trade union did not submit a return, confusing the year of submit. But once the notice from the registrar got, they submitted it. The court held that the cancellation was invalid. The next topic is general fund and political funds. So what are general funds? Under the general funds are compulsory funds. Every member of the trade union have to apply for general fund, have to contribute to general fund. So it is compulsory, mandatory for every trade union member to contribute to general fund. If they don't contribute, then they will be removed from it. So objects, what are the objects for general fund? Where this general fund can be spent? The objects of this general fund are salaries to office bearers. The trade union has office bearers. So if they have to pay the salary to office bearers, then the general fund money can be used for the administration, audit, and account. For the administration of the trade union, the money can be used utilized from general fund. For the prosecution or to protect rights, say if a suit is filed. Wait a second. So if a suit is filed on the trade union, then the fund from the general fund can be used to resolve the dispute for the prosecution or to protect the rights of the trade union. If there is a trade dispute, then the money from the general fund can be used to compensation for the loss caused in the trade dispute. Also, general fund can be used for the death, sickness, or allowance of the members of the trade union. The general fund can be used for the insurance of the workmen in the trade union or the members of the trade union. The general fund can be used for the educational, religious, or death ceremonies of the trade union members. The general fund can be used for the periodical published. The trade union publishes a periodical. For that also, it can be used for the benefit of workmen. If say the general fund has a one fourth of the income left, more than one fourth of the income left, then it can be used for the benefit of workmen from the general fund, and as specified by the appropriate government. If the appropriate government specifies the use of general fund, then there can also general fund can be used. The next is political fund. So how is it separate from general fund? Political fund. So how is it separate from general fund? So in political fund, the contribution is not mandatory. The contribution in general fund is not mandatory. In general funds, it was compulsory to contribute for every member, but in political fund, it is not compulsory. So what are the object for political fund? It is done for the political object. Say there is an election for the selection of chairman in the trade union, then the political fund is raised. It is not compulsory for anyone to contribute. Those who want to volunteer can contribute. What are the objects where a political fund can be spent? For the expenses of the candidate, say for the election candidate, for his expense, you can utilize political fund, meeting, distribution of literature for candidate, etc. For his advertisement, for the candidate's advertisement, the literature that are used, you can use political fund. For the maintenance of person in legislation, the political fund can be used. For the registration or selection of the candidate, the political fund can be used. And for political meetings also, the political fund can be used. Immunities of a registered trade union. So, what are the immunities of a registered trade union? The registered trade union has two immunities. It is immune to criminal conspiracies, and it is also immune to any civil suit. So, it has two immunities. It is immune to criminal conspiracies, and it is also immune to any civil suit. So, when it is immune to criminal conspiracies, so this section 17, provides immunity to members and office bearers in criminal conspiracy by section 120B of IPC. Under section 120B IPC, they are immune to any criminal conspiracy. But are they immune to every criminal conspiracy? The answer is no. The object should be legitimate and agreed by all the members. For the criminal conspiracy they are forming against, the object should be legitimate, and all the members of the trade union should have agreed for it. So when they will form a criminal conspiracy, say for example, an employer is really torturing all of the employees. So what the workmen will do, they will form a criminal conspiracy to get him resigned itself. So that's a criminal conspiracy. It's illegal. But if they are a registered trade union, it will not be illegal for them. They will be pardoned if they form a criminal conspiracy. There's a case, West India Steel Company Limited versus Aziz. So what happens is, during the employment hours, the trade union member secretary, he obstructs the work of all the member of all the workmen and asks them to stop the work for 5 hours. but he was held liable for this conspiracy because during employment hours he cannot cause any criminal conspiracy or obstruct the work. Section 17, immune to civil or civil suits. So the trade union, apart from criminal suits, it is also immune to certain civil suits. See, it is tortious to breach or induce breach of contract between employer and employee, but a registered trade union is immune to do so. Say, if a contractor is if the employer is getting into a contract for his business and the trade union is trying to breach the contract, it will be tortious normally, but the registered trade union is immune to it. So immune if induces a person to break a contract of employment, interference with trade, business, or employment of some other person, or with right of other person to dispose of his capital or of his labor as he wills. Not even if not covered in clause like threats, violence, or other illegal means employed. If the trade union employs threats, violence, or other illegal means, then they won't be immune to any of it. They should be done. It should be done in non-violence means. There's a case. Rohtas Industry Staff Union was the state of Bihar. So in this case, it was held that the employer can't claim compensation from the trade union or the workmen's if, say, by any civil conspiracy or criminal conspiracy, the trade union caused damage to the employer, then the employer can't claim compensation from them. The next is question is change of name and amalgamation of trade union. If the question will come like this: change of name and amalgamation of trade union. Section 23 talks about change of name. Section 24 talks about amalgamation of trade union. This is the synopsis. First, we will see section 23, change of name. Can a trade union change its name after getting registered? The answer is yes. If the two-third majority, if the two-third of the majority of the trade union workmen agree to change their name, then the trade union can change its name. The next is section 24, amalgamation of trade union. What is amalgamation? Amalgamation is the merging of two trade unions. Merging of one or more trade unions is called amalgamation. Can a trade union get amalgamated? Yes, it is. They have provisions that a trade union can get amalgamation. The method for amalgamation of two or more trade unions is provided under section 24. Any two or more registered trade union may become amalgamated together as one trade union with or without dissolution or division of the funds of such trade unions. See, every trade union has a general fund and a political fund. So without merging their funds, the trade unions get amalgamated. They can get amalgamated, yet they can keep their separate funds. Half of the total votes of 60% in favor. To get amalgamated, the trade union should get a 50% voter turnout, and the 60% of the votes should be in favor of amalgamation. So there should be a 50% voter turnout. Half of the members of the register, they should be voting. Voting should be done. First, they should have to do a voting. If half of the members of the registered trade union vote and 60% is in the favor of amalgamation, then they can get amalgamated. According to section 25, notice of change of name or amalgamation. So how they can get amalgamated? They have to provide notice in a writing of in writing the change of name of amalgamation signed by 7 members of the trade union and the secretary, and they should give this notice to the registrar. And if the registrar, if satisfied, will change the name, will amalgamate them. So what are effects of change of name and effects of amalgamation? It is covered under section 26. Section 26 1 talks about effect of change of name. What happens when registered trade union changes its name? It does not affect rights or obligation of trade union. It does not affect any legal precedents by or against the trade union. If a legal proceeding is going on of a trade union, when it changes its name, the proceeding will start with the new name. It will not disrupt any legal proceedings. Section 26(2), effect of amalgamation. What will happen when a trade union get amalgamated? It does not prejudice any right of trade union or any right of a creditor at any of them. So it does not prejudice any rights, changes any right after amalgamation. They will still have their registered trade union rights. There's a case, Booth versus Amalgamated Marine Workers Union. See, what it says is amalgamation is not a proof. After if the registrar registers the amalgamation, then it is not a proof of amalgamation, because if the 50% voter turnout is not there, the amalgamation will be cancelled anytime. If someone complains that 50% members have not voted, then the amalgamation can get cancelled anytime, even after registration. That is what this case says. The next topic is collective bargaining and trade disputes. Collective bargaining, it contains the first definitions, methods, types, and settlements. All this will be asked for 10 marks. Explain define collective bargaining, its methods, types, and how settlement is done. Like this, the question will come, and it will come for 10 marks. So, what is collective bargaining? It has two definitions. One is given by International Labour Organization. Say, in simple terms, collective bargaining is a negotiation between employers and workmen. In simple terms, the collective bargaining is negotiation between employer and workmen to solve the dispute. That is simple definition. Now, in-depth definition have been given by these two, International Labour Organization. So, according to International Labour Organization, negotiations about working conditions and terms of employment. So, it is a negotiation between about working conditions and terms of employment between an employer, a group of employer, or one or more organizations of employers on one hand, and one or more representative organizations of workers on the other hand, with a view to conclude agreement, is known as collective bargaining. So what definitions they give is, it is a negotiation about the working conditions and terms of employment between an employer or a group of employer or an organization of employer on one hand, and the other side an organization of labor workmen to conclude agreement, is known as collective bargaining. The next definition is given by Ludwig Teller. The Ludwig Teller defines the collective bargaining as an agreement between a single employer or an association of employers on the one hand and a labor union on the other, which regulates the terms and conditions of employment. So the basic definition is still holds good. So it is a negotiation between employers and workmen to determine the working conditions, the terms and conditions of employment. That is collective bargaining. So what are the methods of collective bargaining? There are four methods of collective bargaining: negotiation, mediation, conciliation, and arbitration. So what is negotiation? In negotiation is the process of settling the differences by face-to-face roundtable talks between the representatives of the employees and the employers. The employees and employers will sit in a round table and they negotiate. That is called negotiation. This is the definition of negotiation. The employers and the employees, the workmen, they sit in a round table and they negotiate. The next is mediation. If the matter is not solved through negotiation, then they appoint a third person, the third party called mediator. He will come and he will assist them to negotiate. He will not give any judgment. He will just assist them to make a judgment, and his judgment will not hold good or is enforceable. He is just a mediator. He will assist both the parties to gather to come into a result. Mediation. The next is conciliation. Conciliation is similar to mediation, but the mediator is appointed by government itself, and he is called conciliation officer. So this is official. If it is not solved by mediation, then the government itself, appropriate government itself, appoints a conciliation officer, and the conciliation officer forms a committee of the employers and workmen, and he will try to solve the dispute, and he will send the report to the government, appropriate government, whatever happens. Even his term is not enforceable. So next is arbitration. If if the negotiation not solved by negotiation, mediation, and conciliation, collective bargaining, then they will use a arbitration method. In arbitration, the workmen and the employers agree to take a third person, and whatever judgment he gives, they will consider it under arbitration. Under mediation and conciliation, the third person judgment is not enforceable. He will just assist. But under arbitration, they will appoint a third person to give judgment itself. So there are two types: voluntary or compulsory arbitration. Under voluntary arbitration, the workman and employer, they hire a person to give judgment, and when he gives judgment, it will be enforceable in the labor code. It will be binding, and they both parties have to agree. And the second one is compulsory arbitration. In compulsory arbitration, the government itself will specify a member to give judgment, and when he gives judgment, it will be mandatory on both, enforceable. The next part is types of collective bargaining. There are 5 types. Distributive bargaining. First is distributive bargaining. In this, one party benefits at the expense of the other. So in this type of bargaining, one party gets benefited and the other party is at loss. Like for example, increase in salaries or providing bonus, workmen will get benefited, but the employer will get a loss. So it is a one-sided argument, distributive bargaining. The next is integrative bargaining. In integrative bargaining, both the parties get benefited. Like for example, the trading of stock. The employer agrees to for the trading of stock it costs the employer, but will also benefit the business in long term, because if better trained workers will give better results. And another example of integrated bargaining is the workers may agree upon lesser salary for better working conditions. So workers will reduce their salary, but they will ask employer to provide a better working conditions. So integrated bargaining is benefit to both. The next type of bargaining is productive bargaining. So both parties negotiate about productivity and pay. So the whatever the conclusion they take, it is for the productivity or the betterment of the company. So example is union may suggest higher salaries would result in better productivity. So union will ask for increase the salary, but the business would suggest a target oriented bonus. So what business will say is no, we will not provide higher salary, but we will give bonus to whoever does good to the company. So the bargain is production productive oriented for the company's productivity. The next is composite bargaining. Under composite bargaining, the negotiation that focus on a number of elements that are not related to pay. So the in counter composite bargaining, the negotiation is not related to payment. Like for example, factors such as working conditions, policies, recruitment, and disciplinary process. So these are not covered under pay. So under composite bargaining, all the bargaining that does not relate to pay or the payment of the or the salaries of the workers. The next is concessionary bargaining. Concessionary bargaining. So what is concessionary bargaining? Unions give back previous benefits, for example, salaries, bonus, etc., to the employer. So it is during the tough times, the concessionary bargaining. Say the company is going into loss, then the trade union itself will decide to give all their salaries, to reduce their salaries, and it will ask the employer to save the company. That is concessionary bargaining. It is during the tough times. So how the settlement is done? You have it is same as methods. While writing settlement, you have to just mention the methods and explain it again in single point. That concludes the chapter.